So this is what we're going to do today. So today we're going to just look at the differences between VAWA 2013 and VAWA 2022 around the issues, the crimes of domestic violence, dating violence, and violation of a protection order. So we're going to have a discussion of domestic violence, and then we'll have an open question session. We're going to talk about dating violence and another open session, violation of a protection order, and another one. So that's how we'll go, and then we'll end up with some resources for you all. So just as a reminder, so VAWA 2013 affirmed the tribal inherent authority to exercise these, this criminal jurisdiction, but only over the three crimes: domestic violence, dating violence, and violations of protection orders. And then VAWA 22 builds on this framework and adds additional categories. Both of these are amendments to the Indian Civil Rights Act, and both the 2013 amendments and the 2022 amendments can be found at 25 USC 1304. And it's really, really important for you to keep in mind that VAWA 2022 takes effect on October 1st. So it's not effective until that date. So quickly, VAWA 2022. So it replaces the term special domestic violence criminal jurisdiction with special tribal criminal jurisdiction. And that's just because it's now so much broader than just domestic violence crimes that they changed the name. It introduces this term about covered crimes to describe that. And then it changes what can be charged in tribal court, and in some cases, who can be charged. So what can be charged? So these are the covered crimes now, right? So we're going to talk today about domestic violence, dating violence, and protection order violence. But then you can see these other 6 are also added: sexual violence, stalking, sex trafficking, child violence, obstruction of justice, and assaults against justice personnel. And we'll have similar calls to this one later on. And there'll be a slide at the end explaining that as we go between now and October 1st. So who can be charged? Also, yes.
May I interrupt you for just 1 second and ask if you could put your PowerPoint in full presentation mode? Oh. We see the slides going down the side. Thank you. I think it'll make the text a little, okay, we'll try that. I think it might make the text a little bigger for everybody.
Okay.
If not, just continue on.
Well, I always have to figure out how I do that.
Go to from current slide. Go down a little bit. There you go. Oh, it disappeared.
That's because I was over here.
Okay, slideshow, and then there you go.
Ah, is that better? Okay.
Much better.
That looks great. Thanks.
Yeah. Okay. So then who can be charged? So let me ask you this. So over on my right side, do you see the people like I do or not? Okay. Anyway.
Yes.
Yes. Yes, we do.
Right. So I'm a tech person, can you tell? That's why we have Marlon here. So it clarifies that in obstruction of justice and assaults against tribal justice personnel, the victim does not have to be an Indian. So, you know, if you have non-Indian police, non-Indian clerks, judges, lots of other people, they can now be the victims of these crimes and can be prosecuted in tribal court. And also then this sufficient ties, right? We always had that language about you have to live or work, you have to have a qualifying relationship. None of that applies anymore. And also clarifies that tribes in Maine can implement this law if they want to. Again, no tribe is required to either implement special domestic violence jurisdiction under 2022 or the special tribal criminal jurisdiction under 2013 or under 2022. So make sure that there's nothing in your current constitution or code that prohibits the exercise. And then consider the following. So what changes do you need to make to either your constitution or your criminal code? And you want to think about not just the crimes, but also jurisdiction, crimes, and due process. And then under 2022, one of the new requirements is you have to give notice in writing to defendants of their rights. And then thinking about what kind of training is going to be needed. And then, you know, if you're not even implementing VAWA 2013 at this time, there's some more things you should be thinking about. Do you have a public defender program? Do the judges have the required training? What kind of facilities do you have for incarcerating people? Are you going to have to make changes to your jury system? And how are you going to fund all of these things? So these are just some things that going forward between now and October 1st and or between now and either adopting DVCJ or STCJ that you should be thinking about. Let's talk a little bit about these ties to the tribe. All right, so 1304 talks about under VAWA 2013 says that the tribe may exercise special domestic violence jurisdiction over a defendant only if the defendant resides in Indian country, is employed in Indian country, or is a spouse, intimate partner, or dating partner of a member or an Indian who resides in the Indian country. So right now, there's this requirement of these special relationships. Here's what 2022 VAWA did to that. It just redlined through all of that. And so now in 2022, there is no language like this at all. So these requirements are now gone. And it's something when you're thinking about what our code looks like, did you put these kinds of things into your code as a requirement when you're going to prosecute a non-Indian? And if so, then this is one of the things that's going to have to get changed and amended and taken out of your code. So I'm going to stop at this point and see if there's any questions about what we've talked about so far. So do we have any questions?
Steve, I think we have to stop the recording if we're going to do a discussion.
Right. At this point, we're going to stop the recording. Every time we get one of these questions, slides comes up, we're going to stop the recording so that we can have a full and open discussion among all of us. So at this point, we're going to stop the recording. All right. So now let's talk about domestic violence and how these two laws treat domestic violence. So this is just the verbatim language out of VAWA 2013 on what the definition of domestic violence. So it's violence committed by a current or former spouse, and then these relationships that are required. And we'll talk a little bit about that, but let's look at what that means, right? So just breaking that down, and you're going to get a copy of, if you haven't already, there'll be a link to these slides. So I'm going to skip over some of them just so that we can talk more about it. So the current current definition. So the VAWA 2013 definition is domestic violence is violence committed by, and then it's a current or former spouse, a person with whom the victim shares a child, person who's cohabitating, and then a person similarly situated to a spouse. Okay, and I've bolded that last line there because it means that your tribe has the opportunity in your own laws to define what that would mean. So that could be kind of like some sort of traditional or ceremonial marriage, perhaps, that would not be recognized by the state. It would be, or the federal government. It could be what the states or oftentimes talk about as a common law marriage. So you have the opportunity to define what a person similarly situated to a spouse of the victim, what that language means. The 2022, as you can see, has a bunch of different language in it, but some of it is the same. And we're, again, this is just the verbatim out of 2022. So let's look at what the differences are, right? So this is the red line version. You can see what changed, what got added, right? So the stuff in red all got added. So instead of violence committed, it's now any violation of the criminal law of the Indian tribe. Okay, so it's any violation of the criminal law, whatever that might be. So whereas before it had to be a violent crime of some sort, it doesn't have to be a violent crime. It's any violation of the criminal law. Okay, now also though, look at these next, and you can see where the relationships required under domestic violence stays the same. So you still have to be a current or former spouse, person with whom they share a child who's cohabiting, or similarly situated to a spouse. And again, just bolded here to remind you that you have the opportunity to define this for yourself under your own tribe's law. And here's some things just to think about in terms of the domestic violence piece. So it's no longer violence committed. Now it's any violation. It still requires that relationship test. Okay, so you need to be thinking about what code changes will you need to make. And in some circumstances, you may be able to use your current STCJ code without changes, or if you've never adopted STCJ, and if you adopt all of the rest of the requirements of VAWA 2022, you may not have to do a whole lot of change to the actual criminal elements part of your code. So just as an example, right, if you have a current crime of theft in your code, the defendant who's non-Indian steals something of value from the victim who's a tribal member. So now we have, there's the proper relationship between the two of them. You could charge theft, but you also then need to include the relationship in the complaint. Because my guess is right now in the crime of theft, it does not require you to show the relationship test if you charged a tribal member, for instance, with the crime of theft. But under, if you're going to use, your current code, you need to make sure that when you're charging, you also charge the jurisdictional requirements. And so these relationship tests are those jurisdictional requirements. And so this is one of the resources that TLPI has available. You can go onto their website and get this. So it's tribal domestic violence courts and tribal domestic violence dockets. And if you can see there, it says, the guide for development of a tribal victim-centered specialized court or docket to more effectively address domestic violence cases. It's only a couple of years old. Obviously, because of that, it doesn't include VAWA 2022 information, but it does guide you through actually setting up a DV court or even just a DV docket within your court setting so that you can be more victim-centered and be more effective in addressing DV cases. And I think we're back to questions. So again, we're going to stop the recording and open it up to questions. And we're going to start up the recording. Dating violence. So again, I'm going to go through it kind of like what we did before. So here is the VAWA 2013 language, right? So dating violence. is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. And how do you decide that? If it's a romantic or intimate nature, this relationship, it's length of the relationship, type, and frequency of interaction. Right? So again, here is that broken down a little bit. So it's violence committed, person has or is in a social relationship of a romantic or intimate nature, and determined by the length, type, frequency of interaction. This is 2022 language. And here is the differences. Again, violence committed is no longer there. And now it's this any violation of the criminal law. Okay? And it's your criminal law, not the federal criminal law, not the state criminal law. It's your criminal law, any violation. Okay? So, but do notice that this social relationship is still required. That's still a part of the definition of dating violence. And you still determine that in the same way, length, type, and frequency. So points to ponder here. So again, no violence committed language. Any violation of the tribal criminal law is okay. Still requires the social relationship. And some things to be thinking about is what code changes will you need to make? So if you just cut and paste, if you are implementing STCJ right now, and you just cut and pasted the definition of dating violence out of that law and put it into your law, then your law still has the violence committed language. And if you don't change that, then come October 2nd, October 1st, you're still going to have to prove violence committed. So that's a change that you would have to make under those circumstances. And again, can you use your current code without changes, or even your current non-STCJ code without changes? And you have to make sure that there's no extra requirements in your current code. So does it require violence committed or not? And also remember, again, when you're going to charge, if you're going to use your current code that doesn't have this kind of social relationship language in it, you're going to have to plead and prove that. So those are the kinds of things you're going to want to think about as we go forward. Notice there's not a lot in these because they're not new crimes that are being added, but what they are has changed and enlarged greatly because of this any violation of the tribal criminal law. But you're probably fairly familiar with prosecuting DV and dating violence crimes. And I think we're back to questions, so we'll stop recording.
Let's start the recording. Sorry, Marlon, I was coached to give it a few seconds. I get excited. So one of my favorite topics, and I've gone through the participants list, so happy I've got advocates out there listening, because I think there's a little something for everyone as we move through protection orders under VAWA 2013 and then protection orders under VAWA 2022. Then we'll move into the actual crime of violations of protection orders under both of those versions of VAWA. All right, Steve, next slide. So we start, I start my piece with VAWA 2022, and I want you all to look at this. So I have put in red the change. Okay, do you see? It's very small. So we really kept our definition that we had under the Indian Civil Rights under the 2013 version. You can relax. I'm not going to read this to you, but I do want you to take a few minutes and scan through it, because for purposes of prosecuting a violation of a protection order against a non-Indian, the order, no matter what it's called, needs to fit within this definition. But I can tell you it's broad sweeping. It includes orders that are issued as temporary, permanent, civil, criminal. So what we have in this first paragraph A, any of those definitions, any order that fits that is a protection order. And look at part B, anything listed there is a protection order. And you go to the very last three pieces of the sentence there. If the order was issued in response to a complaint, petition, or motion filed by or on behalf of the person seeking protection. So easy A, B, also, if you can meet the requirement of the last few sentences there. So let's go to VAWA 2013. What are we doing right now for those tribes that are exercising this jurisdiction over non-Indians? You'll see it's almost the same, almost exactly the same. So you don't have to read that one. Let's go to the next slide, Steve.
Well, before we do that, Kelly,
Okay.
so this last piece that you read, where it's in response to a complaint, petition, or motion filed by or on behalf of a person seeking protection. So that's the language that sort of stops courts from voluntarily creating mutual orders, correct? I mean, so the victim comes in and says, I'd like to files a complaint, says, I want to have a protection order. They have a hearing, and at the hearing, the perpetrator says, yeah, I want one too. Right? So the judge says, okay, fine, I'm going to give you both one. Right? So that those mutual orders then may or may, the order that's issued against the perpetrator on behalf and protects the petitioner is a valid protection order under this definition, but the one that protects him from her is not. Is that correct?
Well, I think under your hypothetical, your definition might actually fall under A if it's for the purpose of protecting. So I only see, and again, this is an open question of law, but I only see that requirement of that filing there if you're going to try to get the order in under B. And what I might say there, I mean, a hypo I can think of perhaps off the top of my head. Thinking some tribal codes have almost a mandate for a tribal prosecutor in any domestic violence related crime to seek a criminal no contact order, which may, depends on how it's worded, but it may fall under this broad sweeping definition of a protection order. And if that victim doesn't want the order or there's some sort of issue there, I think the prosecutor can request it, but it has to be on behalf of the victim seeking protection. And if the victim doesn't want it, it may not fit within that. But if it's for the purpose of protection and that sort of thing, it may bump up to A. So it's a little fuzzy why it is created this way and written this way. And I'm just saying it's open. I've never seen a case interpreting this. But one other thing I want to point out is this definition of a protection order I'm giving you right now under this 2013 that's on the books right now under the Indian Civil Rights Act. It is different. This definition is different from the definition of protection under VAWA, full faith and credit. And we'll talk more about that, what that is later. But I just don't want everyone to think, oh, well, this is the definition of protection order for anything. This is the definition we go to when we are wanting to prosecute a non-Indian for violation of a protection order. First thing is we need to see if the protection order fits within this definition.
Thank you.
Mm-hmm.
Next slide.
So next slide. Yeah. All right. So my points to ponder here. It's a very deep thought. VAWA 2022 made no substantial substantive changes from 2013. So those of you who are familiar with that, you advocates, trying to make sure that putting those protection orders, saying, do we fit within A? Do we fit within B? It's just about the same exercise here. I would argue it is the same exercise here. So no radical changes here. Next slide. Now let's look at the actual crime of violation of a protection order. And this is the 2022 version, again, not going to be effective till October 1, 2022. And not every tribe is going to be ready to move forward under this particular statute, but it's so important for all of you to have the information, especially those of you who might just be on the edge of implementing STCJ. You can go back, and not every single provision of VAWA 2022 requires sweeping changes. So here's what it is. This is the newer version. I put in red the change from VAWA 2013. There it is, all of one change, and it's a little a. Instead of a participating tribe, you can look at the next slide, and we'll go over it in more detail because they're very, very similar. It's the, so it changed. VAWA 2022, somebody didn't like the word the and put a in there. But let's look at it, what it means here, because I know that many of you advocates out there working with victims of domestic violence, and those victims are reporting back to you violations of the protection order. Oftentimes you may be called upon to sort of explain some of the parameters of the violation of that protection order. And I'm talking about the non-Indian perpetrator here, because if it's an Indian perpetrator, tribes can prosecute according to the law and not worry about these particular pieces here. So let's look at it. The violation, in order to be prosecutable against the non-Indian, the act has to occur in the Indian country of, it's the tribe that's prosecuting, basically. So the act. So let's think about that for just a minute. I would want you all to be open to the argument, and Steve might want to have a few words to say about this too, because we've gone over this in depth. This act may be continuing. So for instance, let's say there is a protection order that prohibits, look down to B little I, it prohibits contact or communication with the victim, all right? So they're maybe at the Walmart in the town, which is not on the reservation, and she gets in her car and she leaves and she's heading back, and she answers her phone and it's him. So that is a violation of the protection order. Now, we're not in Indian country yet, but she crosses over the reservation boundary on her way. Now we might have a continuing act. Now we've got an act that started in the state and it's moved over into Indian country. He can make the call, arguably, outside of Indian country. She answered the phone inside Indian country, and you could argue that act occurred in Indian country. So be open. Sometimes we get those continuing acts or repeated calling. So I just want you to have a really broad view of what occurring in Indian country means. Now, let's move on to the next piece. It's not a violation of every provision in that protection order. The statute says the only violations that you can prosecute under this statute and under VAWA, remember they're the same, it'll be VAWA 2022 as well. The provision in the protection order that says these things or mean these things, prohibits or provides protection against violent or threatening acts, harassment against, sexual violence against, contact or communication with, or physical proximity to another person. And we're going to find out another person. In order to be a victim under these statutes, you have to be a protected party. And the safest way to interpret that is the name needs to be on the protection order, or the judge in the order, next best thing, says this person is protected by this order. So that's a really important piece. So not if there's failure to pay child support, if the order doesn't prohibit contact or communication with and doesn't have any of these other provisions in it, it's not going to be enforceable criminally through this statute. Couple of other requirements. The protection order must have been issued against the defendant. It must be enforceable by the participating tribe. And what that means, look at your tribal code. Does it have a criminal provision for violation of a protection order when the violation is committed by any person? You've got to look back at the tribal code there. Also, this protection order, even if it fits within this definition, it has to be consistent with federal law. Many of you are already familiar with this. This is the full faith and credit for protection orders under 18 USC 2265B. What it means is this: the order must say the tribal court has jurisdiction over the subject matter, the protection order, must have jurisdiction over the defendant, and must jurisdiction over the defendant, and the due process, notice and opportunity to be heard, have been given to the defendant. He knows this has been filed, was given an opportunity to have a say in court. So all of that looks like a lot, but VAWA 2022 didn't change much of it. And I know that there's been lots of training going out to the advocates on this, because I do feel like not always advocates are often first responders, and they have this rapport with the victim so that the victim is comfortable coming in talking about these violations. Next slide. Points to ponder. My points to ponder. Okay, thank you. Okay, so again, no substantive changes. I know I've been talking probably 20 minutes about no substantive changes, but it's a great thing here, because what you have here is going to remain consistent, and not a whole lot of new training needs to go out there maybe. So here's a couple of things to remember though, and Steve already pointed these out, but I just want to bring them up again. When you read through the statutes, and this is true for VAWA 2013, 2013, it's true for VAWA 2022, the victim must be an Indian. So that's going to be important. There's the definition of victim. It's a person that's specifically protected by the protection order that the defendant has allegedly violated. And I do want to point this out. In a prosecution for violation of a protection order, you don't have to talk about this special relationship that Steve went over. Spouse, intimate partner, child in common. You don't have, that's not an element for a violation of a protection order. So unless the tribal law requires that, because we do have to default to tribal law here, but it is not a requirement that the petitioner and the defendant be in any sort of relationship unless that is required by tribal law. Next slide. All right, so tribes that are prosecuting violations of a protection order under VAWA 2013, this is the older version. What are they going to do? Some tribes aren't going to be ready to actually bump into 2022 right away. So we want to give everyone an opportunity, and Steve said this before, continue on according to code for 2013 if you've already met the requirements there. So here's what has to be proven though under VAWA 2013. The definition, violation in Indian country, a specific part of the protection order has to be violated, and on, you can look down. Here's the big change right here. This is what has to be proven right now, and this is not an easy task for a tribal prosecutor. It can be done. It's not an easy task. The defendant, the tribal prosecutor must prove that the defendant resides in Indian country or is employed in Indian country or is the spouse, intimate partner, or dating partner of a tribal member, doesn't matter where the tribal member lives, or is the spouse, intimate partner, or dating partner of an Indian And this Indian non-member must reside in that Indian country. That's a lot. That's a lot for a prosecutor to have to handle. They've been doing it, but let's look at the next slide. That are ready to implement VAWA 2022 on or after October 2022. So here, just look at this list. It's missing any reference to the defendant resides or is an intimate partner of a member or a non-member who resides in Indian country or works for the tribe. All that is gone. It is gone. And I would take this burden as a prosecutor any day over the burden in 2013. So that the effect of that, I hope, will be more violations of a protection order in India for crimes committed in Indian country, the violation that's committed in Indian country. And next slide, and I think that might be my question slide. So Steve, if you want to stop the recording, if anybody has any questions about any of these, I know we've had PL 280 mentioned, those sorts of things.
So if you notice, one of the things that Kelly talked about was, that in this protection order, that the victim has to be an Indian. And the reality is that in all of VAWA 2022 and VAWA 2013, except for those crimes that we talked about earlier, which was the obstruction of justice and assault on a justice personnel, everyone else, the victim has to be an Indian. And so it raises the question of who's an Indian? And so here's that language. So 2013 is this: you may not exercise special domestic violence criminal jurisdiction if neither the defendant nor the alleged victim is an Indian. And here's the changes then in 2022. And so it's still that same, except for the obstruction of justice or assault of tribal justice personnel. Other than that, the victim still has to be an Indian. Okay, so then how do we make that determination? Well, within the Indian Civil Rights Act in 25 USC 1301, there's this definition. And it's important to remember this is only the definition of Indian for the purposes of the Indian Civil Rights Act. This is not the definition of Indian for the Indian Child Welfare Act or many, many other kinds of federal programs. So we're just going to talk about it in relation to Indian civil rights and who you can, right? So who the victim has to be in one of your either special domestic violence criminal jurisdiction cases or in a special tribal court, tribal criminal jurisdiction case. Okay, so it's 1301 says, oh, well, it's the person who would be subject to jurisdiction of the U.S. as an Indian under 1153, Title 18. So you think, oh, okay, well, I'll go over to 1153 and it'll tell me who that is. Well, here is the language from 18 USC Code 1153. Any person who commits against the person or property of another Indian or other person, and then there's a whole list of crimes. That's it. There is no definition of Indian in 1153. So this is 1153 is part of the Major Crimes Act. And so that's been around for a long, long time. And courts have had to make some determinations over time about, so what does Indian mean? And so I am going to, these next couple of slides are slides from different resources that I want to talk to you about. So here's the first one. So to be considered an Indian, one generally has to have both, quote, a significant degree of blood and sufficient connection to his tribe to be regarded by the tribe or the government as one of its members for criminal jurisdiction purposes. And you can see this goes clear back to United States versus Rogers in 1846. So they, and there's 1984, all kinds of of case law that has gone on since then. Okay. So you have to have a degree of blood and sufficient connection to the tribe. Now, one of the things is the tribe has to be a federally recognized tribe. And there is some case law out there about what happens when a tribe is disestablished, which has happened in our history, unfortunately. And basically it says, well, then you're not an Indian anymore. And the reason for that is because even though you have to have a significant degree of blood, this can't be race-based. It has to be, the political connection to the tribe based. And so that gives the tribe some leeway also in trying to figure out who is an Indian, right? How do you make that determination? So here's a couple of more cases, or a couple of more comments there. So enrollment has not been held to be an absolute requirement, okay? So Indian doesn't have to be enrolled, but it's the common evidentiary means, but it's not the only means, nor is it necessarily determinative, okay? And these two slides came out of the Department of Justice Manual. So it's the manual that the prosecutors use. I don't know how old it is, but it's in the archives, as you can see. So whether it's current or not, I don't know. But this case law is still around, and as far as I know, has not been overturned. And so here's some other case law. Notice most of this is out of the Ninth Circuit, but what I did was, I looked through Indian law in a nutshell, and I looked through Cohen's, the latest version of Cohen's Handbook on Federal Law, and a couple of Indian law textbooks, and got some of these cases out of there. And I really only want to talk about one of these because I think it's a fairly important, has some important language in it. And that's this US versus Cruz. And to be honest, the Ninth Circuit did not come up with this test. A district court judge in South Dakota, is my understanding, is where this originally came from. But there's that two factors, right? So there's the degree of Indian blood, and has tribal or federal government, have they recognized you as an Indian? So those are the two factors. So the first prong, is fairly easy. You either have Indian blood or you don't. If you don't have Indian blood, actually it could be very technically difficult, but if you don't have any Indian blood, then at least for this test, then you could not be Indian. There apparently is some conflict in the law about whether an adopted non-Indian person could or could not be an Indian for the purposes of criminal prosecution, and we're trying to find the case. The Rogers case that's cited above said no, but we're convinced that somewhere out there in the world is the other one that says this person could be. So it's a little less than absolute, but it's pretty absolute. So it's really this second one, the second prong, that really gets litigated in these cases. And so these are the four factors that South Dakota court came up with, and has then been used here in the Ninth Circuit. So they look at, and again, it's important, in declining order of importance. So they look at tribal enrollment. Are you enrolled or not enrolled? Again, enrollment pretty much answers the question. If you're enrolled, you're Indian. If you're not, you're not. Well, you may not be if you're not enrolled. So it's not determinative, right? So government recognition, formally and informally, through receipt of assistance reserved only to Indians. So, are you getting treated for your healthcare through IHS? Are you getting money taken care of by BIA social services? Those are some kinds of things that might show that you're getting that. Are you a student, or were you a student at a BIA school, right? Then enjoyment of the benefits of tribal affiliation. And this doesn't necessarily mean that you have to be able to vote, but there may be other benefits of being affiliated with the tribe that you could be part of. And one of those might even be something like, the tribe has their own, they have a contract on an IHS clinic. So it's no longer an IHS clinic, it's a tribal clinic, and you're getting your health care there. And then finally, social recognition as an Indian through residence on the reservation and participation in Indian life. It was interesting because there was, in looking through these cases, there was a reference in one case to a 1913 case that said, well, yeah, they might have lived on the reservation, but, they don't take part in any of the kind of cultural things, and then the next comment was, well, that's probably not going to fly today in today's world, but that was a definite, a disqualifying factor at that point. I see there's some things in the chat, and I don't know if any of these are questions about who's an Indian. So I guess,
Right.
Marlon, can we stop?
Go ahead, Jerry.
I was going to say, it doesn't.
We're going to record the resources. Okay. If you have any questions about that, you can email me. My email's in the chat box. So let's talk a little bit about the resources that are available. So here's several that are available through the through TLPI and NCAI, right? So there are several books and other kinds of resources, and at the bottom you can see that there are the addresses, internet addresses for both NCAI and TLPI. So some of these are real, well, all these are really great resources that you might want to take a look at, particularly and remember that all of these are already published. So none of these are going to cover VAWA 2022. And so, sorry about that. So, just remember that these are going to be older ones. Yes.
Can I say just a couple of words about the TLPI publications? They're free. You can download them. I think we've given you the link there. The purple one you see in the middle there is if you're interested in developing a tribal domestic violence court or a tribal domestic violence docket as you're thinking about implementation or springing into VAWA 2022. And the gray one at the bottom, there's our newest release, and it's a code for drafting tribal codes that address crimes against children. And we'll get into the child violence piece in one of our calls here. So be looking for that, and we'll bring that back up to you. And also I see a comment from Rebecca Jones somewhere in here from the Office on Violence Against Women. The Battered Women's Justice Project, and you can Google that, has resources, they're very good resources available on Full Faith and Credit. And she gives you the address there. Also check out TLPI's tribalprotectionorder.org for a specific, for drafting tribal protection orders that will meet Full Faith and Credits. I agree, super important for victims, directly at the heart of victim safety. And Kelby from NCAI, the Intertribal Technical Assistance Group, ITWIG. If you want to join the Intertribal Working Group working on all of these sorts of issues, there's a link there. Okay, Steve's address is in there. And Jerry, did you want to say anything else about the resources we have listed?
No, I think just there's a couple more slides. We just want to quickly cover those.
Okay. Well, and then, so this slide then is the tribalprotectionorder.org. That has lots of, again, great resources here. And here's a note about, there's a White House symposium. So they're going to have 4 sessions All right, so the first one is on April 27, 2022, from 3 to 4:30 Eastern. And I think Marlon was going to drop the internet address into the chat box so that you could do the registration for this if you wanted to. So this first one is celebrating the reauthorization of VAWA and providing more information on VAWA implementation to the tribes. So that's something you're going to want to watch if you have a lot of questions about how things are working. Here are our upcoming discussions. So on May 20th, so I think the rest of these are all on the third Friday of the month. So next time is obstruction of justice and assaults against tribal justice personnel. Just remember that those ones, you don't have to be Indian if you're the victim. Then we'll do sexual violence and stalking, child violence and sex trafficking. And then the last one will be the Alaska provisions, along with habeas corpus and exhaustion of tribal court remedies. And let me see. There's still some more information and links in the chat box if you want to do them. But we want to thank you very much for being on the call today. We want to thank you for your participation. And we look forward to talking to you on May 20th, again, about obstruction of justice and assaults against tribal justice personnel. Thank you.